5-2-0. Counts 1 and 3 are dismissed. And in the other matter, we'll accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be set for
5-8-2-0. It's going to be April 28th at 9 a.m.
April 28th, 2026, 9 a.m. That's the sentencing before. Your name, sir?
David Childs.
Thank you.
I'm sorry, Your Honor, Mr. Childs just said something. Could I get clarification?
You may want to hit the button so we don't have to go ready to
All right, thank you, Your Honor. Okay. At this time, my client wishes to waive the preliminary examination. He's going to sign the waiver form right now, and we'd like to address bond.
Yeah. Is there a reason all my informations are missing? Like the second file. Sir, you're waiving your right to a preliminary examination?
Are you waiving your right to a preliminary exam, sir?
Yes. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing and that you'll proceed to circuit court.
Yes, Your Honor.
For further resolution. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of the information. Waived, it's on the record, and at this time, my client wishes to stay on mute and have the court enter a not guilty plea.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for April 7th, 2026, 1:30. Judge Conkey has to bond.
Your Honor, we're requesting that that the court would consider one of two options for Mr. Childs. The first is to grant him a personal recognizance bond. He has been in custody for, I want to say, 2 months at this point.
Longer than that.
At least 2 months at this time. He is a small business owner. He owns his own flooring company. He can return to that work. He can be released on tether to the address in the file and has no problem with the no contact order or no go to that area order. Part of the reason for my confusion or not being quite clear about his dates is because this case is a reauthorization case. However, the original felony was reduced and was pending in district court up until yesterday. So with that, in terms of the total time with regard to these incidents, it would be more than that.
Response.
This case is right. This is a reauthorization. It originally was an exam and was remanded. However, right after it reached out to let us know that she hadn't made that court date or wanted to participate and was still scared of this defendant. She was present today. We talking about it. He was waiting. I would object. He has 2 previous domestic violence convictions from 2023. In this case, he pinned the victim to the ground from his knee to her neck and punched her in the head. She had a front back from the neck. He also grabbed her by the shoulder, stood at her along with pushing her around the house. So given that, I would ask for bond remain as set, Your Honor.
And did the previous, are they involving this same individual or no?
Yeah.
I do not believe so, Your Honor.
I mean, I don't know that either one is good, but anything else, Ms. Kane?
Our alternative request would be a release to substance abuse treatment.
I don't have a problem signing release to substance abuse or inpatient treatment.
Yes.
And so if that order's prepared, I'll sign that. But as to the changing of the bond to a personal recognizance, that motion is denied.
Would that be with the tether?
It would be with the GPS teller. That's,
All right, thank you.
thank you.
Mr. Morgan, who is joining me at the podium. Mr. Morgan, would you state your name for the record?
Each of his cases, I have before me a plea form that indicates that he's going to plead no contest to, in the case ending in that 5820 or 5320. He added count 4, counts 1 and 3 would be dismissed. And in the other matter, he would be pleading to an added count 2. Both counts are aggravated assault. There is further a sentence agreement and no upfront jail. That's the court's full understanding of the agreements.
The defense agrees. Thank you.
And haven't lost.
You solemnly swear and affirm that one of your mouth will be the truth, the whole truth, and nothing but the truth shall be done.
Yes, sir.
State your name, please.
Dane Morgan.
Mr. Morgan, it's this court's understanding. Bad assault. Those are misdemeanors punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
2 things about a no contest plea I have to make sure that you understand. First is it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that, sir?
Yes, sir.
You understand, sir, that although I'm taking your plea, I would not be your sentencing judge. And in the case ending in 5820, you would be sentenced by Judge Garwood. And in the other matter, you would be sentenced before Judge Perry.
Yes, sir.
You understand that, sir?
Yes, sir.
Basis for the no contest, please.
Lack of memory.
Sir, to the charge of aggravated assault as contained in the case 5820, how do you plead?
No contest.
To that same charge as contained in the other matter, so it's a 55, can't read their writing. 5535. How do you plead?
Guilty.
Or
No contest. No.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form in each of these cases?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Let's get a look at paragraph 5. There's a copy on the podium.
This is the same form you
Those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
Court has been provided and has reviewed Ann Arbor Police Department report for their case number. Let's get to it. So, no. Close it out and click back. Actually, it's University of Michigan Department of Public Safety for their case number 2590304546. And in the other matter, University of Michigan Department of Police report for their case number 267326. Any objection to the court having reviewed those reports?
Thank you. None from defense.
Based upon a review of those reports, court does find that there's a sufficient factual basis in which court could find a defendant guilty of these offenses. Sir, I do have to advise you upon me taking your plea that if you commit misconduct between the time I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to these pleas?
No, Your Honor. Thank you. No, Your Honor.
And have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's plea to count 4 in the case ending in 5820. Counts 1 and 3 are dismissed. And in the other matter, will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14th or 15th District Court probation. Sentencing in this matter will be set for
5820. It's gonna be April 28th at 9 a.m.
April 28th, 2026, 9 a.m. That's the sentencing before Judge Garwood. And in the other matter,
April 24th at 8:30 a.m.
April 24th, 2026, 8:30 before Judge Perry. Bond will continue.
Did the court dismiss counts 1, 2, and 3 on that case, or was it 1 and 3?
Just everything that needed to be.
Thank you, Your Honor. Appreciate it.
Thank you, Your Honor. On behalf of Mr. Moot on the case ending in 1665.
Morning, Judge. Brian Bowling, Assistant Public Defender, on behalf of Mr. Moot in the cases ending in 5712 and 5718.
Okay. And are these all waivers or?
In case number 5718,
Yes.
the necessary witness did not appear in the claim examination.
I would move, my understanding is that both charges would be dismissed here, Your Honor, so I'm moving to dismiss both charges based on.
People being unable to proceed, cases dismissed. That's on defendant's motion. All right. And the other matters, sir, you're waiving your right to a preliminary examination.
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Correct.
People also waive their right.
Due judge, and for the record, we did make a plea agreement prior to the waiver where Mr. Moot has been waived, almost respect to waive, and plea to the charge in 5712, that being possession of a narcotic thing. And then in 25F2165, we will offer a plea to larceny, $201,000 in circuit court as a global resolution.
That is my understanding of the people's offer as far as my case is concerned, and also awareness of the other case, and have discussed that with Mr. Moot, and he does wish to waive based on that offer.
That's my understanding of the agreement, Your Honor.
Defendant having waived preliminary examination, he's bound over to circuit court in the case ending in 5712 on count 1, and in the other matter counts 1 through 3. As to the arraignment, gentlemen.
Oh, yeah. Wait formal reading of the charges in my case ending in 5712. Your understanding is as for a pretrial thing.
Defendant having waived. Oh, go ahead, Mr. Fred.
Acknowledge receipt of the information, waive formal reading, and stand mute as well, Your Honor.
Defendant having waived formal reading, standing mute to all charges. Court will enter a not guilty plea to the 4 counts. Pretrial in these cases will be set for
May 19th at 1:30 with Judge Conkey.
May 19th, 2026, 1:30 before Judge Conkey. Bond will continue. Thank you.
Thank you very much, Your Honor.
One moment. Your name, sir?
Bobby Tennyson.
It's waiving.
Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right?
Yes, Your Honor. And I mean, put down the record.
Go ahead, yes.
Offered to agree not to add a offender notice in each.
That's correct. That is correct, Your Honor.
Looking for why. I don't know. Why do I not have information in here?
Thank you.
Well, Your Honor, I don't intend this as an insult, but I have a copy of the information.
No, I've got it now. Well, I've got the copy of the complaint, or at least the front one. All right.
Your Honor, my client waives.
Examination having been waived, defendant is bound over to circuit court on counts 1, 2, 3, and 4.
There's 6. I think there's 6 counts total, Your Honor.
Well, I have.
There's the drug counts, and then there's 2 counts of firearm.
Yes, I see 6. All right. So it's actually counts 1, 2, 3, 4, 5, and 6. You're right. Got it. It's on the other page.
There's only 6.
Your Honor, I believe there may be, the information I'm seeing about has 8 counts with it.
Except the one that I have has 2 of those counts by the magistrate count what would have been the original complaint, counts 3 and 4, that there was a finding of no probable cause.
Understood. Thank you.
Yeah, the copy I got when I got my discovery, Your Honor, has 3. I have 6 counts total.
I'll update our file then. I apologize.
He's bound over on all 6 counts, Mr. Golson.
Your Honor, we acknowledge receipt of the information, copy of the information. My client waives its reading, stands viewed as that a not guilty plea be entered.
Defendant every way for reading, standing mute, court will enter not guilty plea. Pretrial will be set for
May 19th, 1:30 with Judge Punky.
May 19th, 2026, 1:30, Judge Coffey. Bond continued.
Your Honor, there is a co-defendant who was bound over to Judge Hamoud. I suspect I should just deal with the circuit court on that. I believe it was Judge Hamoud.
Yeah. Mario Taylor was bound over to.
I have judged this case in 2 places. This Judge Conkey.
I'll deal with circuit court, Your Honor.
Bond will continue.
Thank you.
What we just watched is a perfect example of how quickly courtroom proceedings can move when experienced attorneys, prosecutors, and judges are all working through multiple criminal cases in a single session. The hearing began with a defendant voluntarily waiving his preliminary examination, meaning he gave up the opportunity to challenge whether prosecutors had enough evidence to move the case forward. His attorney then requested a lower bond, arguing that he had already spent months in custody on a flooring business and could safely return home under GPS monitoring. However, prosecutors strongly opposed that request. They pointed to the defendant's prior domestic violence convictions and described the serious injuries allegedly suffered by the victim, including a fractured back. After considering both sides, the judge denied a personal recognizance bond but agreed to allow release for inpatient substance abuse treatment under strict GPS monitoring. The courtroom then shifted through several other cases. One defendant entered no contest pleas to aggravated assault charges as part of a negotiated agreement, while another saw all charges dismissed because the prosecution's key witness failed to appear in court. We also witnessed additional defendants waive preliminary examinations, accept plea agreements, and move their cases to circuit court for future proceedings. These hearings highlight an important reality about the justice system. Court outcomes often depend not only on the evidence itself, but also on legal strategy, negotiated plea agreements, witness availability, and judicial discretion. Every decision made during these hearings can have lasting consequences for everyone involved. What are your thoughts on these courtroom decisions? Were the judge's rulings fair, or would you have handled any of these cases differently? Let us know your opinion in the comments. And don't forget to like, subscribe, and turn on notifications for more real courtroom breakdowns.